We want to talk about the powers and duties of directors. So the duties of directors, they are at common law and by courts of equity. And we have two: duties of care and skill, and fiduciary duties. So what are the duties of care and skill that we talked about where a director is employed? The care and skill that is expected of him is that of a person holding his qualifications. You're not expected to be an expert, but that does not mean that you'll be allowed to be negligent at what you do. So in City Equitable Fire Insurance Company, this is what they held. And a director need not exhibit in the performance of his duties a greater degree of skill that may be reasonably expected from a person of his knowledge and experience. And this duty is partly objective because it talks about a reasonable man. And it's also partly subjective, that this reasonable man is deemed to have the knowledge and experience of a particular director. So when we say a reasonable man, we don't mean anyone just on the streets. We mean a person we can compare on a certain level, that the two of you are able to match the duties and the skills that you have. And it's also expressed that, say, if a foolish director makes foolish decisions resulting in loss to the company, he cannot be liable for negligence. It would be unreasonable to expect a foolish director to make wise decisions. However, if the director made very foolish decisions resulting in the loss of the company, he will be liable in negligence, since it is not reasonable to expect a foolish director to make very foolish decisions. On the other hand, a wise director will be liable if he makes unwise decisions, since it is unreasonable to expect him, a wise man, to make wise or foolish decisions. That tongue twister says the duty and care and the skills that you have can only be matched to what is expected of you. You're not expected to be an expert in all that you're doing. Directorship is not a professional job with a legally prescribed qualifications. And all that the law can expect is that you serve the company honestly and to the best of your abilities. You remember, the Act does not give us the qualifications. And this is where the problem comes in, and what we have talked about, a foolish director making foolish decisions. But a wise director cannot be forgiven for making unwise decisions. The fact that there are no legal requirements, you see, as we will go to a company secretary, there are set out qualifications of what one must have in order to represent the company in that regard. And where we have this, then all we can expect of you as a director is that you act to the best of your abilities for the benefit of the company. Again, in the duties of care and skill, a director is not bound to give continuous attention to the affairs of the company. His duties of an intermittent nature are to be performed at periodical board meetings and at meetings of any committee upon which he happens to be placed. He's not, however, bound to attend all, but he needs to attend at least a percentage. So in Marquess of Brute, a director who had attended only one board meeting in 38 years was exonerated from liability of alleged negligence on the ground that neglect or omission to attend my meetings is not the same thing as neglect or omission of a duty which ought to be performed at those meetings. But a company is free to impose a duty on its directors to attend board meetings within a certain period of time. So while the court held that the company will, and this is where contracts come in, that you need to act as per the contract you have signed. So, and if a director is to be made liable, it can only be on the basis of his personal negligence. But we said that delegation is not negligence. Having your colleagues do some of the duties does not equate negligence, because business cannot be carried upon principles of distrust. Men in responsible positions must be trusted by those above them as well as those below them until there's reason to distrust them. Care and prudence do not involve distrust. I want us to take a 5-minute break. We come back at 7:10 and continue with the fiduciary duties. We have talked about the duties of care and skill at common law. And now we need to talk about the fiduciary duties. So, one is that a director is not allowed to put himself in a position where his interest and duty conflict. So where there is a contract, for example, and this director is in the company offering these services, he's not allowed to vote. One, he's supposed to inform the other directors that the company offering to do to either deliver goods or services, that he's interested in them, and two, he's not allowed to vote. He is to recuse himself from such a meeting where his interests and those of the company conflict. He cannot participate in that activity. We have Cook versus Dix. Some of the company's directors diverted to themselves a contract that was intended to be for the company, and they had to surrender the benefit of the contract to the company. In law, the benefit belonged to the company, which the directors had formed for the purpose of obtaining the contract. But in equity, the contract belonged to the company for which it was intended. So he cannot have any chance where his allegiance is torn. If he's acting for the company, he must act for the company in good faith, and to the best of his abilities. And this director is not, unless otherwise expressly provided, entitled to make a profit. You cannot, because of the position that directors have, they're involved in the day-to-day. So they know any business that will be transacted, how much has been budgeted for that work. Say provision of internet services. It is in the board meeting that they discuss that these offices need internet services. So how much do we budget for that? The number of offices and the number of users, and they make a budget. If you're in that meeting, you are privy to information that an outsider is not privy to. So where you leave such a meeting, go and form a company or go collude with someone to come and make an offer. Probably fill out the quotation forms if need be. You know how to guide them such that if their quotation is the lowest, then they will be picked. But what have you done? You have used your position to gain. If you form such a company and this company wins, then whatever profit you have made, you're liable to return the money back to the company. And it is the fundamental rule of the law of agency that an agent must not make a secret profit. You're not allowed to make a breach out of a contract by your principal. You remember we said the director is an agent, the director is a trustee, and a director is a managing partner. So whichever duties that he performs within those three categories. So we have directors' powers, and equity regards directors as holding their powers on it, and they can only exercise for the benefit of the company. Otherwise, that purported exercise will be ultra vires beyond the powers vested on them and therefore invalid. So we have statutory provisions that are provided for in the Companies Act. And they're under various sections. And these are subject to any restriction placed by the articles. And again, these powers and duties that are under various sections and subject to the articles are only exercised when done in meetings and by means of a resolution at meetings of the board and not by circulation. So to make calls. And this is where anyone who took up shares and has not paid up the shares, if you are allotted 20,000 shares, you have paid up only 10,000, the directors will make a call. Pay up. Then the power to issue debentures. We talked about debt capital to the company. It is the board of directors that determines, once they look at the book of accounts, how much money can we raise? And what do we need to attach to that? What are we willing to give a creditor so that they can advance as funds? And where the company feels they can borrow money otherwise than on debentures. You remember when we talked about share capital, the issue of bonus share, where you are given for every 2 held, you get 1. That is also a way of the company ending up that extra share. These things are discussed at the board level, and their ordinary resolutions will be passed to give validity to these decisions made. So how then, if we have issued shares and we have received 10 million into the account, what do we plan to do with this money? Or we have borrowed 50 million or 100 million. What do we plan to do with this money? So that is at a board meeting, and for resolutions to be passed and the power to make loans. And this is where we say the director, the company, cannot act on its own, despite it being separate and distinct. And since the shareholders cannot again do the day-to-day, the power that is vested on board of directors includes this power to make loans.